Hello, my name is Matthew Chan. I am the editor of the extortionletterinfo.com website, which I affectionately refer to as the ELI website. And I have with me this afternoon New York attorney Oscar Michelin. And he has graciously lent his time out of his very busy day to discuss what I consider a fairly important issue regarding Getty images. And of course, any of you who've been following my website know that it's important because I'm the guy one of the guys they're coming after. So obviously, I have a vested interest.
There you go.
Yeah.
How are you, Matthew?
Hey, hello, Oscar, and thank you so much for being on the line today.
No, it's my pleasure.
People have already been reading our website. I mean, as I've already told you, traffic has really picked up a lot,
right.
And it's just been kind of crazy. This whole thing has just kind of grown, and there's so much dialogue. But before we get into that, Oscar, I want to let our audience hear a little bit about what you're all about. How did you come into this thing? How did you find out about Getty Images to begin with?
Well, we had been contacted because of a website called AVO, which is a lawyer website, and someone had posted a question which we responded to. And with respect to Getty Images, my firm is a litigation boutique firm in New York City, and we do a number of different types of litigation, but certainly one of our core areas is entertainment law and intellectual property. And, we saw that there had been a lot of buzz, as you said, over the Internet with respect to these Getty Images issues. And so I answered the question, and that led to you contacting me about putting that post up on your website. And, frankly, I agree with you that since then we really have had so many contacts from different businesses and individuals who've received these Getty letters, and we've been able to help a fair number of them already try to respond to them and put them a little bit more at ease.
So when you answered that question, I guess it kind of opened up a can of worms. You kind of looked into them. You Googled them, right, I assume?
Right. Exactly. And what happened was I wanted to find out how big the issue was because, of course, I had heard of Getty Images. I was well aware they were, one of the larger holders of photography.
Yes, they're big names.
Right. And so I was very concerned because it was only a matter of time before some of my existing clients might receive these letters, because they represent not only web developers, but a lot of people who have, obviously, media on the Internet, and I wanted to find out what was happening out there. One of my biggest concerns was, is Getty filing lawsuits?
Yes.
And are they following up on their letters? So in addition to Googling the issue, I also went on to various federal court sites to try to search for any Getty Image-related lawsuits. And luckily, so far, we haven't found any.
Right, but that does not mean, we just want to let our audiences know, it doesn't mean they won't, just because you haven't found any.
No, and as a matter of fact, what I've been telling both clients and people who are just generally inquiring through your website, AVO, and others, that it's only going to be a matter of time, I believe, before Getty files at least one or two cases. What I always try to do in litigation, in preparing for litigation, is trying to say, if I represented the other side,
yes,
what would I be doing right now? What would be my plan of attack? What would be my strategy? And what would be my next step? And that's often the best way to try to figure out how you should obviously defend or prosecute litigation, try and get yourself into the mind of the other side.
Absolutely.
So, at some point here, if I was Getty's counsel, I would say to them, look, at some point, you're going to have to file a litigation because a lot of the blogs, yours as well, obviously, which is probably the most thorough on the Internet about the topic, are saying that there have been no lawsuits. I don't think they're going to file. So I wouldn't be surprised if what they're going to do is maybe divide the country into regions and file one or two lawsuits per region against perhaps some of the larger claims. Some people have just one or two images. Others have 10 or 11. Others have a couple of dozen.
Wow.
And then file those claims in those areas so that the word kind of gets around everywhere that, Getty's coming. Now, once the first few litigations are filed, they'll probably see a much larger instance of settlement.
Let me ask you this. You and I have discussed this offline, and the thing about it is, again, not coming from a legal background, I always kind of wonder what the intent is. Now, on the surface, I definitely respect what they're trying to do in that, we cannot have people getting into copyright infringements. I mean, it is fairly rampant, and I definitely understand that perspective because I'm a publisher myself, and I am engaged in copyright protection and so forth. So I can definitely relate to Getty Images protecting their interests.
Right.
The thing about that, the more I have studied this case, the more I'm kind of perplexed with what they're trying to achieve. Some people have thought that this is a revenue generator. That is one possible thing. Or is it truly a deterrence? Or is it a combination? Do you think that they really care to stop it? I mean, if it really stopped, they wouldn't have a revenue source. I don't know.
Right. It is a potential revenue source for them, of course. And these aren't large numbers, but you can do the math.
Yes.
As to if everybody pays them $500 to $2,000 per image.
Yes.
They're getting for an image that on their website sells for $49.
Right.
So it certainly is a nice way to increase the value of the image.
Mm-hmm.
But it's a whole number of different purposes.
Yes.
And one of the main ones is it's doing exactly what we're doing right now. It's getting its name out.
Yes.
Everybody knows now that Getty holds photography.
Yes.
That they're the principal distributor and license holder of photography, so it gets their name out.
Yes.
It's excellent publicity in that end, although it's actually
somewhat negative.
a negative connotation to it. But there's that old adage, any publicity is good publicity.
But it also sends a message that people, they mean business about stopping this stuff, right?
They mean business, and also here's the thing.
Mm-hmm.
One of our main requests to Getty when we do respond to them is to say, hey, do us a favor. Before I decide to advise my client to settle your claim, prove to me that you are the license holder and or the actual author or owner of the photograph. And that's actually important because if they don't actually have a registered copyright,
mm-hmm.
then they are not allowed to get the statutory damages that they're asking for in their letter. They may very well be limited to only actual damages. And that's why, of course, it becomes relevant that they're charging $49 for the photograph. So they wouldn't be able to get these large amounts unless they had a registered copyright. But by starting this procedure, they are helping to establish their copyright.
Yes.
At the very least, they can point back to, in February 2008, we told the world we held this image. And therefore, since nobody came and said to us after that, wait a minute, that's not my image. That's not your image, that's my image. They have a much stronger common law copyright claim.
Mm-hmm.
So if you think about it, it's a very good way for them to also kind of vet and get out their common law copyright claims for these photographs, to put out to the world that they own these. And very often, one of the strongest ways you can prove a copyright claim is by coming into court and saying, look at the steps I've taken over the years to enforce my claim to this piece of writing, to this movie, whatever it is. So it certainly will help them if they're going to seek damages and other items on these copyright claims that are not registered, to say, look, we've put it out there. We've told the world these are our images, and we don't need to prove any further copyright than that. One of the main issues that they're going to have, though, is trying to prove that these images were not legally available on other websites.
Mm-hmm.
So it's not that simple an issue for Getty. The law is generally on their side, but they have some hurdles that they may have to overcome before they're able to claim as much money as they'd like, or before they're even able to actually prove a claim at all.
Yep, and you brought some good points there. when I got that letter, I was obviously, fearful, and I was very concerned and all that. And actually, I didn't even know. I mean, I was ignorant, and I had no idea that they were lifted images. So, clearly I had no intent. And boy, I tell you, I responded really, really quick.
Yeah.
But the thing that really bothered me the most, I did do some reading on the copyright law, and maybe they are entitled some damages, but to me, it still wasn't clear cut. And I'll tell you why. As a non-attorney, I have been in a court many times for usually as a plaintiff, and for a lot of different things. And I have learned through firsthand experience, sometimes the law may say one thing, but what the judgment or the ruling comes out is a whole different thing. So
that's why there's lawyers.
Right. And so we've had cases where we technically won, but we didn't win hardly anything. It was almost a loss. The practical aspect of it is not clear cut. So when I hear people say, well, or their claim, like Chloe, she says, well, you're clearly in the wrong, this specifies this and that. And I kind of wonder to myself, I was thinking, she may be textbook right, but I don't know if she's ever been in the court. And it's been my experience that, and I could be wrong, Oscar, jump in here, that they look at intent. They very much look at intent as part of whatever judgments they look. They also look at what you can prove, the actual damages. So even if there was an infringement, but it was up there, let's just say somebody infringed on an image for like 5 seconds, okay? They posted up for 5 seconds, they took it down. I mean, how much damage was there? Maybe there was. I don't know.
At most there, you would any reasonable attorney would argue at most would be whatever they would charge as a license fee for that photograph, which is usually somewhere between $49 and $99 as far as their actual damages. Now, the other issues are that they're relying on the fact that copyright law does not require them to prove intent. That's understandable. That would be almost impossible to prove, and copyright is there to protect artists, authors, photographers, everybody. So you don't have to prove intent.
Okay.
However, that is a factor that judges take into account when deciding what to award somebody. And look, when we talk about small businesses that decide to bring in litigation, they don't have unlimited resources.
Mm-hmm.
Getty has unlimited resources in the sense that they can send these letters out and have folks assigned to respond to those letters. And if they break even or even lose a couple of dollars, it's not going to break them.
Yes.
They get the message out and they feel their copyright is protected. But if it came to a court of law,
yes,
I think they would be hard-pressed to try to get these large damage awards when the defendant is going to say, you know what, the minute I received my letter, I took these images down. There was no watermark on the photograph. There was nothing on there that would indicate to me that they had any ownership interest in this photo. I went to a stock photo site and downloaded it. So a judge can say, well, how much am I going to punish this guy? It's one thing if Microsoft did it, they ought to know better. They could do the research. And it's another if it's a smaller business that's just, especially those who hired a third-party web developer now, and, they paid the guy for this website, and they would automatically and correctly believe that the guy used either licensed images or stock, public domain images. So intent will play a part in it in the sense of how much someone is allowed to recover. And, for example, we had a guy who called us just today, and this is one of the few guys that I advised to settle, to get a number and settle right away. He went on to the Getty website, and he copy and pasted the thumbnails of the images, and he used them.
Oh, no.
Yeah. So I said, hey, listen, I'm a great attorney. I think outside the box. We fought a lot of uphill battles, but that's just stealing.
Right. You're not a miracle worker.
I said that's a copyright infringement. You went on to their website. You saw that they sell photographs. They have a catalog of the photographs, and with a price point. And you take the thumbnail. I said, that's really not going to be very good for you. So let's try to figure out a number that they can be happy with and is as low as possible. And that's what he wants to do. He wants to just settle it. Now, by the way, that doesn't mean that we didn't send out the same initial, strong letter and all of that. But different people are in different positions. And those who intentionally took Getty images and photocopied them are going to pay more money and are going to be more responsible than those who either used a third party or did it without knowledge. I mean, it's just common sense. You're not going to be a lawyer to know that a judge is going to look at those two individuals, very differently.
Yes, they are. Now, there's another thing that I'd kind of like bring to light is that I really didn't like the way this arbitrary number is. Now, what was told to me was there was some sort of formula that goes into, evaluating this number. But I found it that it's like hitting a moving target. I mean, just my case alone, they've ratcheted that number down. And it's kind of interesting to me that how quickly they want to resolve this. I mean, they want it to go away faster than I do.
Well,
I don't know if I'm imagining things, but
no, absolutely not.
I mean, what is going on with that? And they don't want to divulge how they come up with that number.
Right, and I have my own little theory about that, which is that they studied and analyzed what they thought would be a large enough number to make it be worth their while to pursue or to get someone to settle against. In other words, they had some wiggle room, they could move down and still make money, and was low enough that would not make people run to an attorney and seek counsel.
They don't like that? Is that what you're saying?
Of course not, because they want to end this quickly. They don't want to spend time and money chasing after these photographs that may not get them more damages than the license fees and a small multiple of the license fee. So the other side definitely would not want to have people run to get lawyers. So if they send letters out and said, we're going to seek statutory damages of $25,000, everyone's going to run and get a lawyer. So if they say, we're going to ask for $2,000, already that small business saying, you know what, I could live with $2,000. What lawyer am I going to find that's anywhere competent in this field that's not going to cost me, more than $2,000? So I'll take the images down, and then if I can save myself a couple of bucks, it's a home run. And now Getty is now very happy. They've been overpaid for their photographs. They've established their copyright to those images, and they've gotten to be the big elephant in the room, so to speak.
Yes.
So I think they've very, very carefully thought about the number. And
those are some well-written letters, I will tell you. It's well-constructed.
Very well-constructed, very professional.
Yes.
Well, and you would expect that. I mean, you would expect that. This is not a fly-by-night company. It's a very well-recognized, very profitable enterprise.
Yes.
And I am sure they had access and resources to good writers, to good attorneys, to media consultants.
Absolutely.
Who gave them the right image, which is one of the things that I think is the thing that they didn't foresee. I don't think that they recognized the anti-Getty backlash that may come from this.
Well, I'm glad you brought that up, Oscar, because I was going to ask you what your professional opinion. For those of you listening to this, this conversation is unrehearsed. I mean, Oscar and I haven't spoken, but he didn't know what I was going to ask, and this is actually a very fluid and organic process.
Right.
As Oscar and I are discussing this live for you guys to listen, I mean, it's just triggering some thoughts in my brain. And having said that, Oscar, what do you think is going through their mind with all this buzz on the internet? I mean, do they care? Do they think, this is a bunch of kooks? I mean, it's not going to hurt them, or is it going to help them? What are your thoughts on this?
I'll say this. I don't think they're going to say it's a bunch of kooks because, excuse me, and it's not just because I have a comment on your website, but any objective reader will see that it's a well thought out. It's not a ranting type of kidnap note of cut, clip out images. It's a well thought out response. You actually are not taking any particular position. You're saying that you found the amounts extortionate, that you thought it was overreaching, and you're just giving out information. And there are a number of other sites and blogs that are doing that. But what's important is if you see a lot of them, from yourself included, are coming from professionals. Because the people they're targeting business owners. They're targeting entrepreneurs. They're targeting web developers, okay? These are not unsophisticated rubes who are selling lemonade on a street corner. So, the backlash is coming from people with brains. The backlash is coming from people with organization and who know how to address the topic and put valuable content out there. You know what I mean? That's your business, actually, right, Matt? That's
yeah, it is as a publisher, right?
That's what you do. So I hope you're able to get a message across and read something coherently. So I don't think by any means that they're either laughing or discounting what's going on out there, and they are balancing the good versus the negative. And I think, again, this is the way that, as I said, I would handle litigation. I would go onto their side and say, well, how would this react if I represented the client? If I represented Getty at this point, I would still say, you know what, keep going.
Well, at least you're honest. Keep on sending the letters out, right?
Well, look, I said, well, if I represent Getty, I would say keep with the program, because if you stop, it's going to bring even more negativity. They're in a little bit of a tight spot in that sense, because they're going to say to themselves, well, wait a minute now. If we stop, we show that we've been doing something that's probably not the right way to go and is hurting our business. What we need to have happen, and I think it's slowly starting to happen, Matt, is that more people do need to kind of push back and say, show me what you have, and put them to some proof, and say, look, I'm willing to do all the other parts of your letter. You know, you ask for a cease and desist. You ask me to take down the images. You may even ask me the source of where I obtain the images, but I'm not paying you this amount of money.
Well, Oscar, you know what was told to me on my phone conversation? They said the cease and desist, and I did find one entry that backed up this claim. It was back from 2002, and it's still out there, that they did do the cease and desist. And what was told to me is that it was not sufficient enough. So they actually upped the ante.
What?
They upped the ante. They, from what I can tell, again, don't hold me to it, but this is based on what I saw. I did find a posting back from 2002 that they were issuing like a cease and desist letter. And in recent years, their claim is, well, it's not effective. They don't care, so we're going to start tacking on the number thing. And in some respects, I hate to admit this publicly, but in some respects, I understand where they're coming from. Right. But however, I'm not them. I'm me. Right. And I know my situation, and I know where my head was at, and I have my own sense of right and wrong. And my personal internal compass says, no, I'm not paying for this. I mean, I shouldn't have to do this. And as a professional courtesy, I was more than happy to cooperate and take it down and all that, and give them an apology and even admit, to say, hey, look, I'm not trying to hide. I've even said on my website, I really don't even know the ramifications of my being an editor. I mean, this could come back to bite me really big time. Yeah. But the only thing that I can say, to anybody else is I'm holding to my convictions. And I'm not doing a whole bunch of name calling and all this stuff because, I don't think that is productive because you come off looking like a nut. I mean, you come, if you're just calling names, and some people have done that. And I said, don't do that. Address the issues.
Right, and also try to provide some information to individuals so they can decide what's best for them. I understand that not everybody has, if you will, the stomach for a fight, even whether you're right or whether you're wrong.
That's true.
Some people would just say, you know what, I don't want to take a chance. We've gotten calls from people who are, sole proprietors, and they just don't have the time.
Yeah.
You know what I mean? They don't want it. They don't want to invest the time, and they say, hey, get me out of Dodge with the cheapest number that you could get. Or some of them I've even told have called me, believe it or not, Matt, after they've already paid exactly what they were asked for in the letter. So people need to know that talk to Getty, and if you feel the need to fold, at least try to work out a reasonable settlement.
Well, exactly. It's incredible to me. I guess people's legal ignorance. I mean, like I said, I guess you can say I have had the good fortune of having to go to court, for various reasons. And boy, I tell you, the lesson of real life teaches you a lot about what happens in a courtroom.
Right.
And the way settlements work and things like that. And, people who just roll over they're just doing themselves a disservice. Even if you want to settle, you can do it intelligently, for God's sake.
I mean, look, here's what happened. Obviously, as somebody who has worked for over 20 years in the American legal system, I think we have a tremendous legal system. I think that in the vast majority of cases it works and it gets it right. But however, here you have a situation, where a large company is taking advantage of a statute that's really designed to protect the individual artist from abuse of their material. And you have this wholesale ownership of these images, or actually a claim of ownership. And what they're doing is they're asking for these exorbitant amounts for very minor, incidental, trivial infringements.
Mm-hmm.
And what they're relying on is the copyright statute. And they're almost, if you will, they're taking advantage of the copyright statute, okay? It's an abuse of that. And I think that if it does get to court, I think it's going to be worse for Getty. I think federal judges are going to say, hey, this is not what the intent of this statute was for. You're taking advantage of these businesses that did not intentionally take your images. You didn't suffer harm, or if you suffered harm, it was at a very minor percentage of this amount that you claimed.
Yes.
You tried nothing to get them to stop. They stopped the minute they found out about it. That's enough. It's a misuse of their rights, and if they have the rights at all, by the way. So, I mean, that's why
has to be determined.
Right. I mean, the response back has to be, listen to me, if you're going to tell me you're entitled to these statutory damages, then you're going to have to come forth and show me that you have a registered and valid copyright in these images. And if you don't, then stop talking about all these large numbers. Show me what your license fee was for that photograph, and here's the check for $49. And thanks so much. So I don't think they're behaving fairly. I think they're taking advantage of their size, and they're taking advantage of their statute. And I think one of the things I love about the American legal system is that the courtroom can be, the great equalizer.
That's what you told me. Yeah.
That's what it's for. There aren't many places in this country where that's still true, and certainly money still rules in courthouses. We know that.
Yes.
But still, you've got federal judges, and if you have a qualified response and you explain what happened, and you say, look, we tried to be reasonable with these people, but they wanted these exorbitant amounts of money, and they never proved to me that they owned the picture. So, what am I supposed to do, Judge? Why don't I just take a photograph from a stock website, search for it, and write a letter to someone and say, I'm the owner of this picture? And what's to stop people from doing that? Just because it says Getty Images, I'm supposed to believe that they're the licensee and the owner? What's the proof to it? And if they can't prove it, it limits the damages. So I worry that people are getting scared and are rushing to their wallets and their banks when they really just need to kind of push back and take a position and say, I know I have rights, and if you're going to exercise your legal rights, we're going to exercise our legal rights.
Exactly, Oscar. And you know what? When I first encountered that letter, I thought I was like a fairly isolated instance, and I was worried, and I was going to do everything I can to try to make this thing right in a peaceful way. But then, I did some investigating. I'm thinking, wait a minute, this is a wholesale scam here in that, wow. I was like, this is really great. I can go ahead and start issuing letters and say, you pay me this, or I will escalate this matter. Now, of course, they're leaning on the copyright law, but if you took that concept and applied it to other things, it's a great little revenue, business model. What's to stop me to go ahead and start issuing my own letters over different things and just prey on their ignorance?
I mean,
go after the ignorant people.
I wouldn't say necessarily ignorant. I would say either they're obviously ignorant of the copyright law, but they could also be busy. They could also be unsophisticated as to litigation. And they see this letter from this monolithic corporation that can outspend them 1,000-to-1.
Yes.
And they say, how am I going to possibly stand up to this? It's very common, for example, it reminds me of like these low-level debt collectors that buy these old judgments.
Yeah.
And they just send out these letters, and there's no way they could ever enforce or collect on these judgments. But they hope that some people will say, oh yeah, I had those credit card bills from X years ago, and they call up and say, what's this about? And say, well, you owe $7,000, and they don't know that it's either been cleared in bankruptcy or the judgment hasn't been properly recorded. They have tons of these defenses. But isn't it cheaper to send $300 or $400? And there are whole kinds of boiler room operations that work just that way.
Yes.
And so this is just kind of a fancier, cleaner, nicer version of that. Until such time as Getty can come forth and say, we've registered these. We've filed for these. These are ours. For example, did you have a written license from the photographer? Because they don't actually own most of the images, Matt. They're actually the license holder. They have the rights to distribute.
That's a very good distinction you make.
Very big distinction, because you know what? Some of these photographers, unbeknownst to Getty, have made these images available elsewhere as well. And then what happens?
In my research into the Getty images, they even make the claims. They're kind of imploring their photographers to start registering.
Right.
So I think they know behind the scenes that a lot of these images aren't being registered. Again, this is just my opinion.
Right.
But I'm just kind of inferring it. If you go to their website, and look at their link, they're actually kind of imploring their photographers to go do this.
Yeah, and I think what they're asking the photographers to do is also bear the cost of that. Each image, would be copyrighted by each individual author, and then there would need to be a license to Getty. So with all those thousands and thousands and thousands of images, that might be harder to do than it sounds. One thing Getty might decide to do is put them all in the catalog and then copyright the catalog as a compilation of other copyrighted images. But then they'd have to clear that with each of the photographers that are in there. It's not that simple. So they've been going on with the fact that they hope these letters will get people to settle without having to prove, their actual claim of right. But if it ever came to court, that's the first thing they'd have to establish.
Do you think that's why they haven't filed thus far, or maybe they don't want to set a dangerous precedent? They lose a case.
I think it's a number of right. I mean, I don't want to speculate, but there's a number of reasons, and you've hit on the two most likely, is that they may be concerned about being put to the test of proof, and secondly, they don't want a court to say it's unreasonable and give them $200, because that could start causing a problem. Now, if they, what I think they would do, though, and this is what I was mentioning before, they would be smarter than that, and they would likely pick some test cases where the claim is clear, where Getty's actually the outright author, an owner of the photograph, and they've registered the copyright.
Yes.
And then they would look for that image on a site that used multiple images, not just one or two.
Yes.
So that this way, the headline when they win would be that Getty gets $10,000 for copyright infringement.
But it would have to be a clear-cut case.
Right, and that's what I'm saying. But they wouldn't know that. They would pick the one clear-cut case of the intentional abuser, and then they would send out media everywhere that Getty started to win these lawsuits. And one of the problems is most people won't get past the headline, and they'll say, "Oh my gosh, Getty's winning, and let me pay." Right. And they won't read the case that shows they filed a copyright or what have you. So people have to be careful. That's the importance of sites like yours that give them information.
Well, what do you think they've been holding out for so long? I mean, what are they waiting for?
I think it's working.
You think the settlement letters are working?
Yeah. So look, you and a handful of others are pushing back and fighting. I think they're probably happy with the return. They see it, like you said before, as a revenue stream, and incidental to the revenue stream is protection of their and declaration of their images. It's like going out into the public square and saying, I own this for 30 days in a row, and then if nobody says different, you own that image type of thing. So they're really doing a number of purposes that they have with it. But one of the things that you have to be mindful of is it's on a very large scale, okay? So
what do you mean by large scale? Do you have some numbers?
No, I'm just going based upon the fact that I've seen inquiry, and I've seen people starting sites, and I've seen people visiting sites from all over the country.
Yes.
And so it's not isolated to, the Northeast corridor, to the, Seattle where they are in the Northwest, to California. It is everywhere. It is also international.
Well, that's what I was going to say. They go through a slightly different channel internationally, but the underlying principle is the same.
Pretty much the same.
So this is an international campaign that they're doing.
Yeah, it's absolutely. And, there are some good links on your site to some of the international pages, if I'm not mistaken. I'm going from memory here.
Yes.
I think you went on to some UK sites, you went on to some Canadian sites that people can look at, and it just gives a good way to get kind of comfortable with what's happening out there in the community.
Yeah.
But make no mistake about it, this could be a very, very dangerous precedent here.
For them?
Yeah, no, it's just well, certainly for Getty, but what I'm talking about is this methodology. If we allow it to kind of prevail and just kind of fold, could be extrapolated to other businesses.
Yes.
And all of a sudden, other people get this idea and start doing it themselves.
Well, that's what I was kind of thinking.
Yeah, no, it's a really interesting phenomenon that could have a lot of repercussions in the way digital media is used on the internet, and how copyright is enforced, and what the values are, and how values are proven. And that's probably why Getty does not want to go forward and get a lot of litigation here, because if all of a sudden the federal judge agrees with our position openly and consistently, then all of a sudden they got a real problem.
Yeah, they got a little bit of a PR nightmare.
A real PR nightmare.
Do you think they see this as a bit of a PR problem right now?
Starting to.
Okay.
Yeah.
But it's not big enough for them to worry about at this point.
Yeah, I mean, look, I'm sure they're aware of the site.
Of course.
I am sure they're aware of, the people who have posted, and also there's a couple of other blogs about it, most of them, again, in Canada and the UK. And so they're watching what people are saying. But what we need, I think, and what would be interesting is if, mainstream media started to pick it up and report on what was happening out there. I believe that it would end up hurting Getty. I think it would be the David versus Goliath situation, because almost everybody that has been involved in this are very incidental, one or two image users. They took it down right away. They're good guys. Mm-hmm. They weren't trying to make profit off the actual image.
Absolutely not.
And right. So they just thought they were using stock. Your case, you use a third party.
Yes.
And I think, it's wrong for Getty to come say, well, that doesn't make any difference. Well, sure it does.
I think it does. Like I said, it could be my ignorance in legal, but I absolutely believe it makes a difference if this got hauled into court.
Right. I mean, look, I'll put it to you this way.
They look at the credibility of the person and everything. They look at the whole package.
I'm driving down the road, okay, and I'm negligent. I misapply the brakes, and I hit somebody in the road and I break their leg.
Right.
Okay. The next day, the same person, another person on the same road, intentionally runs into a person and breaks their leg.
Oh, yeah. Oh,
okay,
yeah.
So obviously, it's the same broken leg.
Yes.
But if a human being, judges are human beings, juries, are going to think differently of that defendant, and they're going to think more favorably of the plaintiff who got intentionally run over, and say, you know what, I'm going to give this guy more than I gave the guy yesterday, because one guy was just an accident. He didn't mean it. This guy meant it. He's got to pay more. So,
the context of the conversation absolutely matters. The context of what's happening. It's not just the end result.
I think we can make it matter, and I think we can make it matter in the sense that judges would say, please keep that in mind when you decide what to award, if anything, to Getty. And also the fact that we advise every client to do what you did, which is take the images down right away. Don't try to keep them up and fight with them while they're still up.
Yes.
Take the image down, and what we say in our initial letters or our initial conversations is, us taking it down is not an admission of liability. It's just an exercise of caution. Okay? Even though we may very well be in the right, we'd rather take the pictures down than be in the right. Okay? So we're not admitting liability. We're not doing it because we think you're going to win. We're doing it to avoid a hassle. And so we took it down. We'll never use it again. We apologize. Thanks for letting me know about it. Now, what are you out, Getty Images? You wrote a letter, okay? And you had a company do this search for you, and that's it. So let's be reasonable here. Let's find a number, like $100, two times the license image. Let's go $150, 3 times the license image, and you go home. Okay, and I get it. I get your message.
Yes.
So.
Well, I can tell you, I've learned a very valuable lesson. I'm usually pretty conscientious, but you just don't know. With websites being so prevalent,
right?
No one really expects that you're going to get smacked upside the head,
right?
Because of something that you've hired somebody out to do on a website.
One of the things that we are advising clients to do who are going to third-party web developers, okay, is to, when you get your little one-page contract, you want to put in there a hold harmless, and you say to the website developer, in the event I get sued for any intellectual property claim, for any of the words, images, pictures, etc., you're going to have to pay for my lawyer, and you're going to pay for my damages. And work that out in a single line or two and say, the first thing is you want a declaration from your website developer that to the website developer's knowledge, none of the images or text
Great advice.
Copyrighted or taken from a copyrighted website, and that to the website developer's knowledge, he has original content or stock content, because it also could apply to text, and it could apply to ideas. It could apply to a number of different things, to video clips, obviously, of course, like images, but also content. People cut and paste from websites all the time and say, hey, just because it's on the internet doesn't mean it's not copyrighted.
Right. Now, before I forget, I wanted to let our listeners know that what Oscar was talking about earlier about the letter, I have read some of his letters, sample letters, and they're very well written. They're very professional. And even when he was giving me advice on my letters, he brought up a couple little points that I totally miss. And that's the power of having someone experienced on your side. I mean, it's not a long letter, but it's a very powerful letter that gets to the heart of the matter, with doing it very diplomatically, but at the same time commanding respect. So I just wanted to let our audience know that if they decide to use you and your letter, they're getting something of value. And I'm just letting the audience know that I have actually seen the letter, so it's not like it's I just have to put that in there. So I get nothing out of it, guys. I mean, you listeners, I get no commission from Oscar. And anybody that knows me knows that I don't endorse somebody unless I really believe in them.
Well, I appreciate that. And then from our point of view, I even had one of the people who did hire us. We charge a very minimal amount to send the letter out. I said, well, how are you doing this? And I said, I'll do it for a number of reasons. Number one, I think this is wrong. I think what they're doing is wrong. So it's certainly a labor of love behind it. Secondly, I represent a lot of digital media companies and websites, providers of all kinds of different content on the net, and they're concerned about these types of things. And I think they appreciate that there are lawyers out there trying to help the smaller businesses respond to this. So it generates goodwill, obviously. It also is the field that I'm practicing in, so it's good for people to see that I'm engaged in this activity on this issue. I think if you look, it's probably one of the leading intellectual property issues that's being discussed on the net right now.
Yeah, it's getting pretty hot.
It's getting pretty hot. It's going to continue to grow here in the States, particularly as these number of claims continue to grow. And so we just wanted to come up with a way that people could retain somebody who might normally be too expensive to litigate a $1,000 claim.
Well, it was so funny. I mean, that's what I was, to those of you listening, when I first met Oscar, I was like, well, Oscar, you're a high-profile New York attorney. You do all these big cases. Anybody that looks him up can easily find all the stuff that he's involved with. Why the heck are you involved with this little piddly little thing?
Yeah, well, number one, it really ticked me off. Number two, I like representing, we do a lot of startups that we represent. I like representing the
underdog,
entrepreneurial underdog startup guy who's trying to do something, that's creative and all of that. And frankly, that's what lawyers are best suited to do, which is try to balance out the power situation from large corporations or from well-heeled, very moneyed people on one side to, those who are just starting out or have a very successful business, but it's not the size of Getty. They're not going to hire a 1,500 lawyer firm. So we relish it. We love it. We enjoy it for the sake of being on the right side in the cause. And also I think it's important to educate people about their rights in this area and let them know that this is what our firm does. So when, for example, like you said before, in the vast majority of cases, we are bringing actions to enforce copyright. So we're no fans of people who take people's content.
Yes.
Let's understand that. We're
Absolutely.
not saying there should be some free access to media, for crying out loud. I disagree. I always agreed with the musical artists who objected to these free, music downloads because these people put their time, effort, creativity, and money into developing these pieces of entertainment, and to have someone just take them for free is not right. Mm-hmm. So this is our purpose is not to say this should all be public domain and you don't get to own these images.
Absolutely
We're
not.
talking about procedure. We're talking about the way they handled it, that they're overreaching and they're charging too much money for very minor, unintentional infractions. That's it in a nutshell.
And I'm glad you brought that up because, I probably, had they handled this a little bit more differently, I probably just would have settled out, but there's just something that rubbed me the wrong way, and I did everything I could to cooperative, and I just felt like there was very little consideration. I said, you know what, if you guys aren't going to do this, you're not going to listen to reason here, then, you know what, I see no point in cooperating.
Right. How about it?
Which spawned the website and everything. See, that's what happens when you piss people off unintentionally.
Exactly right. Or when you try to get too much. I mean, one thing they tell clients all the time, pigs get fed, hogs get slaughtered.
Oh, yeah, that's a great saying.
Remember that you're going to get what you're entitled to, and then you go home, and then you win. And, here, if they had called you up and said, look, Matt, this is the image. We charge $49 for this image. Yeah. And then it cost us another $50 to use PicScout for this particular image. So, give me $100. Give me $150 and a cease and desist. You're not starting a website. You're not starting to entertain, to educate people. You're saying that's a reasonable approach. Yeah. And let me see what I can do. Okay? But when you get a letter saying you're a thief, and we're going to shut you down, and you owe me $2,000 for a $50 image, then all of a sudden someone's going to say, hey, wait, maybe not so fast. Yeah. Maybe not so fast. I think they misjudged that, and I think they're also misjudging the amount of backlash that's continuing to grow on it. To be fair, like us, as we do this interview, we don't want this to be just a Getty slamming session. We want to make this, I admit I have a slight bias, but I am still trying to be a little bit rational and balanced about this. What started out to be something small has now become a cause. Now they think it's about the money. So they ratcheted this thing down. But now, they've just taken me so far. I mean, I promise you, Oscar, I promise you, I may not command an hourly attorney's fee like you, but I have spent way more time and energy than if I had just paid that sucker off. Oh, yeah. You know what I'm saying? Absolutely. And that's what happens when they get tapped to the wrong person. It's all of a sudden it's not about the money because, you see, I don't have a job to go to. So I do have the luxury of, being able to do this. Right, but of course, normally you'd be putting your time into one of your businesses. I mean, that's true. There are only so many hours in a day that you're awake and you're functional, and, you want to do that to try to make your companies continue to grow and everything. This is a distraction. It is a distraction. But it's become a cause for you, certainly, and it takes away from you the time and effort you put into your business. But you know what? It's worth it in the end, I think, not only because you're telling people about it and you're doing the right thing, but also I think eventually, Getty has to come and see that there are better ways to have come at people with this. And we've said it. I know you just gave a little caveat that we're not slamming Getty, but we've said repeatedly that we understand their right to enforce a copyright, and it's just the methodology is what we disapprove of. The thing is, this case reminds me of something, of something else that I've heard about. Crooks will always continue to be crooks. It doesn't matter what you do. Yeah. But generally, people who are law-abiding citizens, you bring something to their attention, they generally don't need to get a beating on the head to take corrective measures. Exactly right. Right. It wouldn't take much. Most people will just boom, they're going to correct the situation. Right. I mean, I have a lot of these sayings that I get mostly from my grandmother. They said, once a cat sits on a hot stove, it won't sit on a cold stove next time either. It's going to avoid a stove in general. It gets the message the first time. A word to the wise is sufficient. We get it. We understand it. Yes. Plus, you've responded in writing now that you're going to cease and desist, that you've taken the images down. Yes. So you're not just telling them. We've written it. We've said to them, look, we got it. We're taking it down. So now, if you end up using it again, now you are intentionally violating it. You understand? Mm-hmm. So they've gotten a lot more than just a cease and desist. They've gotten a promise in writing not to continue to use any of their images. So it ought to have been enough. It ought to have been enough. A cease and desist letter should have come out, and they should have been satisfied that all of these images are being taken down, or people are paying for the licenses.
Right. Well, as we come to the end of this recording, do you have any last words of wisdom or advice, whether it's to our listeners that maybe get this letter or Getty or just anything that you think, some parting thoughts regarding this situation?
My advice to Getty, obviously, if they are listening, is
I'm sure they will eventually.
Be reasonable. Take a look at how the people receive the content
and how they respond,
and also to what your actual damages are, and that if they're reasonable and make it related to what they were actually out of pocket or the people's intent, then I think they'd see that a lot more people are going to think positively about the company and close them down. But I'm not going to speak for them anymore unless they retain me, obviously.
Right, exactly. They need to hire you to make the case for them.
Right, but as far as for the users out there, or the people who are receiving the letters, I would really just say become educated. Read the content. It's not that much on the site. Go through it. Blog about it either on our site or others, and get yourself informed. And if you have any questions, obviously you can post something onto our website, and either I'll respond or Matt will respond, and we'll get the information out there to you how you ought to respond to Getty. Final words are: don't rush to judgment that you're going to lose, and that you need to pay them the exorbitant amounts that they're asking. And don't be afraid ever in this country to exercise your rights.
Right.
So, Matt, I really want to thank you for having the site. The site's fantastic. I think you're doing a great thing. You're really educating the public out there about it, and you're taking a very reasonable stance.
Thank you very much.
I thank you for letting me be a part of it.
Well, Oscar, the way we gotten together, it's just been very, very interesting. I was going alone by myself, and it just kind of ran into your post, and I was like, wow, this guy's really very reasonable. He's very sharp, and I'm just grateful that you were able to see all sides of the issue and give a legal rendering. And so that's why you're the subject matter expert.
Appreciate it.
You're the go-to guy as far as I'm concerned. And,
that's great. And we'll keep people posted and have them come back to the site for more information.
Exactly. So anyway, those of you who are listening, if you've got any other issues you want Oscar to discuss you think might be helpful in a future interview, just post it onto our discussion forum and give us your feedback on what you think this recording. This was unscripted. We tried to do our best to give some good information, but hopefully we didn't ramble too much. But thank you very much for listening. Oscar and I appreciate your time, and we hope this has been helpful to you. Thank you.
Thank you.